Anthony, founding partner of Legal and Compliance, a full-service corporate securities and business transactions law firm. Today is a continuation in a LawCast series talking about the recent SEC investigation and public statements related to initial cryptocurrency offerings, or ICOs. On July 25, 2017, the SEC issued its report on an investigation into an ICO and related activities by the DAO, which is an unincorporated entity, Slock.it, a German corporation, and various principals and participants in the offering. Section 5 of the Securities Act of 1933 requires the registration of all offers and sales of securities unless there is an available exemption. The registration provisions are based on full and fair disclosure of all material information for an investor to make an informed investment decision, including detailed information about the company's financial condition, identity and background of management, and price and amount of securities to be offered. Section 5 of the Securities Act, like many provisions in the securities laws, is written in the inclusive, such that all offers and sales are covered unless an exemption is available pursuant to statute or case law. Section 5 states that unless a registration statement is in effect as to a security, it is unlawful for any person, directly or indirectly, to engage in the offer or sale of securities in interstate commerce. A violation of Section 5 does not require intent. The SEC began its analysis of the DAO tokens by reference to the definitions of a security found both in Section 2A1 of the Securities Act and Section 3A10 of the Securities Exchange Act. Both definitions include the term investment contract, which has been famously defined by the U.S. Supreme Court in the case of the SEC versus W.J. Howey in 1946, as an investment of money in a common enterprise with a reasonable expectation of profits to be derived from the entrepreneurial or management efforts of others. Under the Howey Test, whether an investment instrument is a security requires a substance over form analysis. The Howey Test defines the investment contract as follows. An investment contract for purposes of the Securities Act means a contract, transaction, or scheme whereby a person invests his or her money in a common enterprise and is led to expect profits solely from the efforts of the promoter or a third party. Such a definition permits the fulfillment of the statutory purpose of compelling full and fair disclosure relative to the issuance of the many types of instruments that in our commercial world fall within the ordinary concept of a security. It embodies a flexible rather than a static principle, one that is capable of adaptation to meet the countless and variable schemes devised by those who seek the use of the money of others on the promise of profits. Applying the Howey Test, courts have interpreted a security to include such diverse items as citrus groves, warehouse receipts, chinchillas, minks, diamonds, bullion, payphones, real estate and equipment, condominium units, and when they were offered or sold under circumstances involving the investment of money and an expectation or return through the efforts of others, they were always a security. I'm securities attorney Laura Anthony, founding partner of Legal and Compliance and producer of LawCast. Should you have any questions about today's topic, please visit securitieslawblog.com and lawcast.com or contact me directly. Inquiries of a technical nature are always encouraged.